Hey, everybody here, estate planning attorney Paul Rabelais here. Very excited to bring you this live stream today. Here with a colleague of mine, Eleanor Washburn. She's in South Carolina. We're going to focus on some South issues related to people who live in South Carolina. So, Eleanor, welcome. Good to have you.
Thank you for having me.
All right. So I always like to start out, I have a unique story about how I got into estate planning. The quick version, when I was 8 years old, my grandmother passed away and she left all of her grandchildren a few shares of stock. And so that enabled me to go to law school without the college loans and enabled me to really get a jump start on my law practice. And so it really had a big impact on me and my life. So once I became a lawyer, I said, well, I want to help other families do that. And here it is 30 something years later. So always interested to find out how people got into estate planning. So what's your story, Eleanor?
I'm a practicing lawyer. I've been practicing for about 30 years. I concentrate now only in estate planning. I practiced in lots of different areas of the law, but a few years ago, I decided that this was an area that I really liked. I really found rewarding. I decided just to drill down and just focus on this area and just practice in this area of law, and also the administration aspect of it, the probate and trust administration and that sort of thing. Um, and yeah, so I too, I had some experience in my family helping with some probates of the states and things like that because I was the lawyer in the family, so I had to handle all that stuff. And so I really enjoyed it. And just decided to really focus and be the best at it. And so I rebranded, and that's all I do.
Good, fantastic. Well, we were chatting a couple of minutes before. I'm one of the reasons I do estate planning is because I don't like the fight. When people think of a good lawyer, they typically think of the bulldog lawyer who likes to be aggressive and adversarial. That's not me. I heard you say generally I don't handle any kind of contested probate matters, but so what's your view on the uncontested estate settlement versus the contested and adversarial estate settlement? When do you and when do you not get involved?
Well, I don't I do like being the good guy. You're right. It's nice to be a lawyer that does good things and makes people happy and gets them, in a place where they feel good. But you can't really help sometimes those family dynamics. We as estate planning lawyers do the best we can to make sure that we minimize the possibility of any conflicts, but sometimes people might come to me, I didn't do their planning. They may not even have any planning. And so it becomes sometimes a matter where the family's fighting amongst themselves and that sort of thing. And I try to, if I know that that's the way it is going to be from the beginning, I probably, I probably try to get those things resolved, but I can do it if it happens, but
Yeah,
it's not as fun. So good planning is the best. And actually,
yeah, exactly. And
I think I learn a lot. I've learned a lot from those kind of cases too. It creates good anecdotes, to explaining to your clients what can happen if you do this or that, or don't do this or that.
yeah,
So
I was involved with one a long time ago. I learned my lesson, but um, a father passed away, had four children. One of the children came to me right after the father passed away and said, "I think there's going to be some problems here." And he was saying it lightly because at dad's funeral, all four children each had their own security guard. So and it went downhill from there. So that taught me a lesson as I help people through this and as they make their appointments of which child or children will be their successor trustee or their executor of their will or their power of attorney agent. It kind of, I always go back to that. Well, I always ask that question, if you're naming more than two people to serve in a role, do they really have a good relationship? And that question gets spurned by from my past experience. So you're right. Going through the tough spots makes it easier for us to help people. So
yes.
yeah, good point. And another thing I want to ask you about is when you say you kind of rebranded, tell me a little bit about that.
Well, I was typically, as most people are, I had my law firm, Washburn Law Firm, but I really wanted to change the name of my firm when I committed to just focusing in this area of the law and and be really dedicated to it. I wanted the name of my firm to tell people what I did. So I'm Charleston Estate Planning, and so people know
There we
what
go.
I do when they see my card or my website or something like that.
Yeah, fantastic. All right. Do you handle anything outside of estate planning, or do you really kind of keep that practice limited to the estate area?
Well, I do the administration part, like I
Yeah.
said, the probate stuff, anything that involves probate. I also do some conservatorship and guardianship for adults, disabled
Yeah.
adults. Situations where people come to me because their parent has developed dementia and did not
Right.
have a power of attorney in place, and they're not able to help them pay their bills. And so I will help them get appointed as their parents,
Yeah.
conservator or guardian, or sometimes parents whose children are just turning 18 and they want to get guardianship in case there's some
Right.
issues later
So
with.
yeah, I'm interested in hearing what that procedure looks like. Here in Louisiana, I've handled many of those guardianships. And the way it works is if, for example, a surviving wife, for example, her capacity starts to wane, and she has all kinds of accounts in her name and she's subject to being taken advantage of. So maybe one of her children will say, I think we better get a guardian appointed for mom, take that capacity to transact for herself away from her. So the procedure is really burdensome. It's generally a lawsuit has to be filed against mom. The sheriff has to serve the papers on mom. An attorney has to be appointed for mom because mom's not going to hire her own lawyer. Then, the doctors have to take a look at mom, and then there's court hearings where a judge has to make a determination as to whether mom is able to take care of her own affairs. And then a judge has to appoint that legal guardian. But the whole kind of filing a formal lawsuit against your parent and having the sheriff serve the papers and go through all of that, all the answers is really difficult for families. Is it similar like that in
It's
South
it,
Carolina?
it's very similar, although if it's a very clear case, it's very evident that this person has no ability to handle their financial affairs and their personal affairs. When it's a really clear case, it can be quite simple. You do have to follow all the rules. We don't have to have a sheriff serve, but we can have somebody serve. They do have to be served. They do get appointed an attorney. And if the attorney meets with the person and feels like they cannot participate in their, in that representation, which would be the case if somebody was, had advanced stage Alzheimer's or dementia, then the attorney would get relieved, and then a guardian ad litem would be appointed, and the guardian ad litem, which is often the same person, will do a report. The doctor has already done a report, and if everybody's in agreement, we can sometimes get it done, depending on the county, without a hearing. And
Yeah.
so we just submit a proposed order or temporary order and submit that, serve that, and after 30 days, the court will issue a permanent order. So if somebody is clearly incapacitated, then it's not as difficult
Good.
as
Good.
if somebody, in the case of somebody who doesn't believe they're incapacitated, it's very difficult.
Yeah, it gets a little more adversarial there.
Yeah,
But
and South Carolina tries to not take away all of a person's rights. They try to take the least they try to
least
give them,
intrusive.
yes,
Yeah.
exactly. They try to give them as many rights as they can retain. But even if it's as simple as being able to choose what kind of religious or social activities they're going to participate in.
Yeah, it's just a tough scenario, but
Yeah, it is.
but
But the point lesson is that a durable power of attorney can avoid all.
there we go. Great minds think alike. I was thinking the same thing. And on that note, on the durable power of attorney, I know some states have enacted their own kind of statutory form for a power of attorney, and that seems to work well in those states that have it because all of the third parties, banks, financial institutions, they're familiar with that statutory power of attorney. We don't have that here in Louisiana. Every kind of power of attorney is unique and kind of customized by the attorney who prepared it. What's that kind of power of attorney situation in South Carolina look like these days?
It's the same thing as it is in Louisiana. We do not have a state form. We have a statute, a power of attorney statute that explains what the general powers are of the agent, if you just cite the statute, and that you can also include more powers. And so we all attorneys have developed our own powers of attorney over the years to include all those things that we think are important. And there's something called the Uniform Probate Code that our states adopted, which is an attempt to try to make things, uniform among the states, but
Right.
States will still pick and choose what part of that uniform code they want to
Sure.
have. But it is a document that has to be signed in a certain way. It also has a provision that if that an attorney can certify the validity of a power of attorney, and if you have done that at the request of a financial institution and they still refuse to accept it, you can bring them into probate court, and they would have to pay attorney's fees and costs. So usually a letter like that is all I really have to do to get it accepted in some of these major financial institutions that just aren't used to it. So
Yeah, it's good to see states enacting that legislation because it seems like in the old days, financial institutions, they have their own reasons for not honoring a power of attorney. No, this word isn't in the right place, or it's too old. We don't like it because it's old, or for whatever reason. I've seen powers of attorney rejected for so many different reasons. I remember one recently where there was a whole paragraph about how the power of attorney was durable. But the financial institution said, no, since the word durable is not in the title of the power of attorney, we're not going to honor it. And the problem is if they don't honor it, well, the reason you're using it is because the principal, the person who created the power of attorney, is now incapable. And so you can't go back and fix it. And so, yeah, I'd like to see these states enacting legislation where third parties have to give a reason in writing as to why they're rejecting, and if they improperly reject a power of attorney, they could be subject to attorney's fees and other expenses. So good to see that. So
right, and we're talking about national institutions a lot of times, those national banks that they have to keep up with all the laws in all the states, and so
yeah,
kind of easy for them just to have this checklist and not really know what the laws are in every state. So it's not like Wells Fargo has an attorney for every state. They don't.
right.
But I have found that a letter, and I just tell my clients if they need it anytime, let me know. But I just have a letter that I use that basically says this is a valid power of attorney. Your objections, here are my responses, and if I know what they are. And then, they have a certain number of days to accept it, or I can file, and then they have to pay my attorney's fees. And that usually does it because they're
Yeah.
off the hook, because an attorney has told
Right.
them
Right.
it.
Exactly.
So that puts me on the hook, but I know it's valid because it was my client and I saw him sign it.
Right.
So
Exactly.
yeah.
And then what do you do on this issue of co-agents and co-trustees? We get a lot of people asking us, Paul, I have 4 children. You're asking me who should be my successor trustee or who should be the agent on my power of attorney. Sometimes parents will say, I don't want to offend one of my children by not naming them. can I name, all three of my children to act as co-trustees or co-agents? In the back of my mind, I'm thinking, yeah, you can, but because of these financial institutions, and sometimes they're a little bit fickle, it might be easier to name one and maybe others as backups, or name multiple people and say any of them can act as a trustee or as an agent. So what's kind of your philosophy on when parents want to name multiple children in these kind of fiduciary capacities?
Well, one, I first, get drill down a little bit about why they want to do that. What's the
Yeah.
relationship like among the children? Why do they think that one might get upset if the other didn't get appointed? Sometimes I encourage them just to discuss it with them before they make a final decision, because sometimes they're surprised and they go, oh, well, so-and-so really doesn't want to do it.
Right.
Sometimes, so that's one thing that we can do to sort of overcome that, and make that decision a little bit easier. And the other thing is, I do explain that sometimes there's even one of the counties close to me where I practice occasionally will not even appoint two personal representatives anymore, because obviously it's created issues. And so I just try to encourage them to think about who's that person that's going to get it done and is going to do it with the least amount of drama. And, and it doesn't have to be the local person, but, if you got a lawyer and, somebody that does something that's totally unrelated, I don't know, computer processing or whatever, that's going to be somebody who knows the law would be helpful, but usually they know who's really going to get the job done, and they just don't want to get hurt feelings. Now, so that's true with personal representative and trustee. The other thing, like I said, sometimes probate courts don't want to appoint two of them anymore. Also, banks don't want to accept both of them on an account, say. So let's say we have a trust that we have to administer, and there are two trustees. There's some, recently we've had issues with the banks willing to let both trustees on the account because they can't require two signatures on accounts anymore. Remember in
I
the
have
old
this.
days, we had a check where you could, both business owners had to sign it. Don't do that anymore because we don't process checks the same way. So they don't want, and especially if the trust says that the decisions or the actions of the trustees have to be unanimous or, together. Now on the durable power of attorney, sometimes I will have two people, but I put on there that either one of them can act, that they can act independently. And as long as those people, as long as those agents that you're nominating will act independently, will act, in your best interest, and won't undo things that the other person's doing. And if they get along, I think that that's fine, because there are times when there's a child who's local that can help more with the local things. And there might be a child who, is an adult child I'm talking about, who is just good with finances and can handle all that stuff. And so I think that's okay as long as they get along. So I think you're right. I think it's better to have one person, but there might be reasons to have more than one. I certainly would never recommend three at the same time.
I kind of looked like a fool one time. A good family friend who had never married, never had children. She created a trust, and she named my wife and my wife's sister as the co-trustees when she passed away. Well, she passed away, and I go with my wife and her sister to the bank, and hey, bank so and so passed away. My wife and her sister are now the co-trustees. We need to set up a trust account. And so, of course, we had to wait about a month for the trust instrument to be reviewed by the bank's legal department. And then they came back and said, well, I'm sorry, we won't set up a trust account where there's two co-trustees that have to work together. One of them needs to resign. And my sister-in-law was like, Paul, I thought you were an estate attorney and you would have known something like this ahead of time. And yeah, as much as we do this, we don't know until something like that happens. So,
No, and
yeah,
and the bank, these financial institutions change their rules all the time, and
right.
so we just don't ever know. And
Yeah,
we have a good network of estate planning lawyers, that communicate, through emails and things like that, and we try to share those experiences. So even if we didn't have that experience, we know to look out for it. But yeah, those are the things that happen, and I also I think the most important thing is to suggest that they discuss it with it when they're worried
yeah,
about their children and their feelings getting hurt. Or if they
right.
didn't want to discuss it, maybe write a letter, a letter of intent, why that they've named the people that they've named, so that maybe that will minimize some of the conflict later.
Yeah. And often I find what helps is when maybe I explain the duties that that person will have and say something like, okay, well, when you pass away, this successor trustee that, you're considering whether to appoint one or multiple is they're going to have to do things like sell your house, go around to all of your financial institutions and collect all the funds, set up new accounts. All the while, they'll have to be communicating with all of your other children and all of the other beneficiaries and making sure everyone is kept well informed. And once you define clearly what those roles will be to a client, usually the bell goes off. Oh, I see. That's what they're going to have to do, and then they can say, okay, well, this child of mine or this person
Yes.
is the right
Be
person
good
for
at
the
that.
job. So,
You're right. And
yeah,
I guess I do that too, because I say, here's the job. Who's going to be the best at this job?
right, exactly.
And they usually know.
They
And
do.
yeah,
They do. I find, don't just to sound bad, but I find mothers often are concerned about hurting a child's feelings by not, giving a certain child a role in the estate settlement or estate handling process. But so yeah, usually it's it's such a big job and so much can go wrong, as you know. It's really so important to have the right person. But so anyway, moving on, I want to find out about any unique aspects of the generally the probate system in South Carolina. I know in some states, lawyers, heirs never have to go to court. It's a matter of filing paperwork. Judges sign court orders, relatively streamlined. Other states, not so much. Lots of waiting periods. There's court hearings. You're on, lawyers are on Zoom calls with judges, and it lasts a lot longer. It's a lot more expensive and much more of a hassle. So where does kind of South Carolina fit in that difficultiness of probate
I think
situation?
I personally think that South Carolina is fairly streamlined. So we have again adopted a uniform probate code, or adopted a code from the uniform probate code. And so it's each county has their own probate court, and we have probate court judges, and who are just dedicated to probate issues.
Nice.
Would,
Yeah.
would, yeah, and so and a probate staff. So they're very specialized in what they're doing. We have informal probate, we have formal probate. Informal probate would be more estates that there aren't any matters that are contested. There's clearly a will, it was clearly signed properly. It's just going to be a routine thing and there's no controversy. Formal would be more when, we have a complaint and we have issues that we have to deal with before the court. But the South Carolina Probate Court is very form driven. It's designed so that some people, not all cases, but in most cases, can be done without a lawyer even. So
Oh, wow. Okay.
not all of them, and sometimes you need to get a lawyer involved when it comes to a deed or something like that. But other than that, the clerk says, file this form, okay, in 30 days, file this form, and that they kind of work you along. So there's certain things that forms that have to be filed at particular times. The personal representatives responsible for paying the debts, distributing the assets. The court makes sure that they're distributed properly. We have notice requirements where this might be different than it is in other states, but here, when somebody files an application to be appointed as a personal representative, whether and even if there's a will, there's a notification requirement, and the people who are named in the will are notified, and also people who would have inherited had there been no will. So the heirs are also notified that the person has applied and been appointed as the personal representative. And then we also have a creditor period. There's an advertisement in a local newspaper for, to notify any unknown creditors that this person has died and an estate has been open, and they have 8 months from that date to file a claim. If it's a known creditor, they have a year. So generally, once that creditor period is expired and all the claims have been dealt with one way or the other, then the estate, can be the assets can be distributed, and an accounting is done unless it's waived. So that's another shortcut thing. We can get sometimes
Waive
waivers.
the accounting.
So just we can close that out. So it can be really simple. We also have a couple of situations where there's a even more simplified process, and that would be with estates under 25,000. There's a sort of a shortcut process, as I call it.
Affidavit approach, maybe, or yeah.
That's another that's similar. Yeah, this is actually a probate, but it is just because it's under a certain amount. All of the things are not required, like accounting and all that kind of stuff.
Right.
And then there's also a situation where if the personal representative is the sole beneficiary, then there's a shortcut process, obviously, because they don't have to do an accounting to themselves, and they don't have to, there's not anybody else involved. So that's often the case with a husband and a wife. Wife is the beneficiary, or the husband is the beneficiary when the spouse passed away. So there's a little shortcut process there. So it's not really that bad, considering what I hear from other states.
Yeah, I talk to lawyers in California, and they're like, just, probate's a nightmare. Takes at least 2 years, and it's very, very expensive. So given it's not always a disaster in South Carolina, what's the general mindset among the lawyers and just the ordinary consumers out there about whether to create that living trust to avoid probate and transfer assets to that trust to avoid the probate process? Or are some people still kind of, I think I'll do the will, even though my survivors will have to go through the probate. That's okay. So where do people land in that kind of will versus trust discussion?
So I do explain what the probate process is like. I do explain that if you have a living trust, that you can avoid, some of that process, if not all of it. One way I start with my clients is in terms of just getting our mindset and what happens when we pass away, and how our assets get to the person that we want to have them, and how they get them. And then one of the things that we talk about is, you might have an IRA, you might have an investment account, and you might be able to list beneficiaries on those accounts, TOD, POD. And if that's the case, you don't, it doesn't matter if you have a will or a trust, okay? Because it's going to go the way you have it listed. Same thing with life insurance policies and IRAs, if I said that already. Also we have, sometimes we own things jointly with somebody. Bank accounts often are joint, and they're with right of survivorship. So if one person passes away, the other person has, control of that account. In South Carolina, we have we can have a deed that's joint with right of survivorship. And so that means that if one person passes away, the joint owner owns the property, and we don't need to do probate. And so it doesn't matter if you have a will or a trust. I also explained that a will and a trust do the same thing. They still appoint who you want to be in charge. They still, both of them say who you want to have your assets and how you want them to take those assets, whether in trust or at what age and all that stuff. All those things happen in both the trust and the will. But the difference is whether those assets that aren't joint and aren't with right of survivorship, whether those assets are going to be distributed through probate process or the trust process. So I also explained that a trust administration is still administration. We still have to do the same things. We still have to marshal the assets, liquidate the assets, transfer the assets. So there's still work to do. The difference is that with the probate court, you are on a timeline. Sometimes that's good. Sometimes that's not. It's important for you to do things in the order that they want you to do them and when they want you to do them. And the other thing with probate court is there are fees involved. Okay. So the probate court fees are based on the value of the estate. So all those things factor into whether or not I would recommend a will or a trust, because if most of the assets are going to go by, by some operation of law, or if there's a lot of, real estate, say, for example, that's worth significant amount of money. If that goes through probate, we're going to look at a lot of fees. So I can say, here's what your fees are going to be in probate court. And then we can kind of decide, do we want to spend the money now or make our family spend it later? So the trust does save money if you have a significant estate that will pass through probate. You can't always do a joint with right of survivorship title when you have 4 children. You can do it between, husband and wife, or if you have one child. But so that's sort of how I get to whether we need to have a will or a trust. I'm not one of those attorneys that thinks everybody should have a trust. I just think that if privacy is important, that's another reason that we might not want probate. Sometimes that is important. The expense of probate, if that's significant, then we want to consider a trust. And some people just don't want to do probate, and I understand that completely, and we can do the trust. So
yeah, I feel like, kind of estate planning is that kind of last gift you're providing for your spouse if you're married, for your children if you have children. And I do find a lot of people are kind of heavy on I just want to make it as easy as possible on everyone, because they feel like, okay, this is the last thing I'm doing for my family, and if I'm gonna do one thing right, it's gonna be this. And so I do find people like the idea of the trust. I don't even know it's that so much of a cost savings is the reason, but the hassle savings seems to be really important to people when they choose that trust alternative in an effort to keep their survivors just from the hassle of dealing with lawyers and courts and delays and all of that. So yeah, key, I'm 100% support. Key there is just, I think our job is to give people accurate and valuable information and let them make an informed decision. So so very good there. All right, I want to. You mentioned you kind of had a couple of niches and that you deal with a good bit. And one of those you mentioned was the blended family situation, which is very common these days, as we all know. So, I'd love to hear kind of your thoughts and how you explain this to a couple. Maybe each of them has children from a prior marriage or relationship, and probably in the back of each of their minds, they're probably thinking something like, yeah, I want to provide for my spouse if I pass away before my spouse, but I also would like to protect the future inheritance rights of my children. So love to hear how kind of your approach and how what that conversation sounds like and looks like when you have that conversation with the couple who perhaps each has children from a prior marriage or relationship.
Well, that is something that comes up, and sometimes, they have a prenup. We don't really have to, and sometimes they don't. So so if there is no prenup in South Carolina, when somebody is married, they're entitled to, when their spouse passes away, they're entitled to 1/3 of their spouse's estate. And we call that the elective share. So they
Yeah.
also have to actually request that. If so, in other words, if a spouse is not included in the plan at all and everything's going to, the children,
Mhm.
the spouse can file something and request that they get their 1/3 share. So what we're trying to do is make everybody happy and make sure that, that kind of thing doesn't happen. And so when somebody has been married for a long time, even if it's a second marriage, they do find they want to take care of this person and make sure this person's okay.
Sure.
And there might be a significant difference in their, economic situation, where a spouse might not be able to survive without, anything. But we want to protect the children from being disinherited. So if we do a I love you will, and this is what I explain, if we do everything to my spouse, and if my spouse predeceases me, then to my children, that's fine, except for once you pass away, that can be changed. And
You're right.
so, and that's the same thing, with a will, I mean, a trust as well. And sometimes I'm talking to couples who it's their first marriage and they have joint children.
Sure. Yep.
Yeah. And I'm like, have you considered what would happen if one of you passed away? Because of course they want everything to go to their spouse. And then your spouse remarries. And and changes the plan. And I say to them, you might not think you would ever do that, but you're not going to be the same person when you're older. You might not have as many marbles as you have right now. You might be unduly
Right.
influenced by somebody else, and that is really hard to prove. And so, by unduly influenced by, caregiver, new wife or something. So anyway, so I say there is a plan that we can do where we can avoid that as much as we can anyway. So with your 50% of the joint assets and your own personal assets, we can make sure that your children get those assets. But we also make sure that we can make sure that your spouse, if they need access to those assets, they have the ability to use them for their health, education, maintenance, and support. So basically they use their own assets first. And if they need this other, these
Sure.
assets in this other pot, it's there for them. And then when they pass away, what's remaining in that trust goes to the children. And the surviving spouse can't ever change that. So they can change where their own estate goes.
Of course. Right.
We can't avoid that, but we can protect, our children. So some people say we don't have a concern about that. That wouldn't, and I have to just respect that. But my job is to tell them what can happen, and then we just kind of go from there.
Yeah. Another one of those, some lawyers say put it in a trust every single time. Well, that's not fair. You need to let them decide.
Right.
I've had many, for example, husbands tell me, I'm just going to leave everything to my wife because I just feel like there is no way that she's going to let these assets go to anybody other than our children. And so I'm like, okay. And then there are some capital gains tax benefits to the I love you will. If everything is included in the estate of the surviving spouse, then everything gets that step up in basis when the surviving spouse dies. So yeah, a lot to it, lots of decisions, and it can be a little bit of a sensitive conversation to have with that married couple because we're saying, well, what if one of you dies and the surviving spouse meets someone new, falls in love and marries? It's a little bit sensitive. So I always start that conversation with with what I'm about to talk about, would you prefer that I give you the blunt version or the sugar-coated version? And they always like, well, give it to me blunt. And so that kind of gives me permission to talk about, the surviving spouse might remarry, and then we have a great conversation. So
And
we
I
have a
say,
lot of fun with it.
I'm sure you can't imagine that, but you're not always going to be, you may not always, have all all the
Right.
senses you have right now, all the sense you have right now.
Yeah, I think the big problem out there, given the kinds of things that people own and the blended family situation, I think the big problem is the IRAs and the retirement accounts, because when someone sets up a 401k account or rolls their 401k into their IRA, just kind of the part of the initial get my account set up paperwork is who's going to be my beneficiaries.
Mhm.
And there's usually no thought put into it. It's just, okay, I'm opening my account. Here's my account number. I need to designate beneficiaries. Of course, my spouse is primary, children contingent, and then they just get on with their lives. And the will and the trust have nothing to do with where their IRA goes, and sometimes their IRA is their biggest asset. And then that married person who's in their second marriage, dies 20 years later, and 20 years earlier they had just named their spouse as their beneficiary because they thought that's what everybody did. And then it all goes to the spouse, and then it all winds up going to the surviving spouse's children. So yes, as estate planning lawyers, we can kind of draft around that leaving everything to the surviving spouse problem in their wills and trusts, but we don't have necessarily all of the control over the IRAs and life insurance policies. So sometimes we have to dig into that.
Right.
And well, one more technical point. Yes, many people do exactly what you said, Eleanor. They set up their estate. So if they die, their estate or their portion of it goes into a trust for the spouse. When the spouse dies, it goes back to their kids. But if you try to set up a traditional IRA that way and leave it to a trust, we've got all these required minimum distribution rules, and all the funds may be distributed to the surviving spouse under the required minimum distribution rules before the surviving spouse dies. So the children of the first spouse get none of the IRA. And so, yeah, with my thoughts on the IRA, especially if the children are adults, maybe leave if a husband, for example, has two children from a first marriage, maybe he leaves 50% of his IRA to his surviving wife, leaves 25% each to his two adult children. That way, the children inherit something from that father when the father passes away, and he's also taking care of his surviving spouse through naming them as a partial beneficiary. So the
Yeah.
IRAs are tricky when it comes to blended families.
Yeah, they are. And but I think that's a good solution, especially if the spouse doesn't really need all of that income, to live. It is very difficult when somebody has a lot of retirement assets, even when they are leaving those assets to their children, that IRA, because we used to be able to, put, set up trusts for the children and get their IRA, and so they would be prevented, basically by the trustee, if they could, from taking distributions, and that IRA could grow significantly over their lifetime until their retirement age. But now, you have to take all of a inherited retirement account over 10 years. So we don't really have the ability to control what our beneficiaries are going to do with that IRA beyond 10 years, because they have to take it out. And we can't, we can keep it in the trust, but we're paying a lot more in income tax and things like that. So it's made it a lot
Exactly.
trickier. It's made it a lot trickier. But as part of the estate planning process for me is to look at all of these assets and make sure that the beneficiaries on those assets line up properly with the plan that we just created. So we want to make sure that the beneficiaries are going to accomplish what we want to accomplish, because some
Right.
people don't understand that just because they did this will, that they don't have to go and look at all their beneficiaries and make sure that they marry each other, and they're going to be all on the, they're going to work the way you want them to work. So that's an important process for me with my client. Before I let them go, we look at all these things. I'll tell them how to list their beneficiaries, and that sort of thing. So I think that's an important part of the process.
Yeah, I had a situation about a month ago. A daughter contacted me and she said, Paul, I've been taking care of my mother for the last 5 years. My sister has been estranged from my mother. So a couple of years ago, my mother changed her will. She said the mother wanted to leave everything to the daughter who cared for her mother for the last 5 years of her life. So that's what mother did. Mother changed her will, left her entire estate to the one daughter, left nothing to the estranged daughter. Well, mom died, and they started looking at the IRA beneficiary designations, and mom didn't change any of that. Nobody told her, she didn't know. And so, that was one of mom's biggest assets was her IRA, which didn't get revised. So the estranged daughter got half of that and created some chaos there. So that was a good story to
Right.
emphasize to people, hey, it's really important that you got to look at the big picture and all of the different pieces and make sure that the beneficiary designations on IRAs and life insurance and other assets are consistent with, just like you said, kind of the estate planning goals and the way things are set up in the will and trust. So
Yeah,
good point
I
there.
have seen those issues too, and so I try to avoid that.
Yeah. All right. Well, look, let's see. We got a couple of questions here.
Okay.
Eleanor, you don't know Larry, but Larry is on every one of my live streams. Larry's on with us. Larry, hey, from South Carolina and Louisiana. We know you're in California. Good to have you here today. In fact, Larry says hello to all on the live stream. Hi, Paul and Eleanor, he said. So Larry says hello.
Oh, good. Hello.
So, all right. And then how can a living trust save assets for seniors on Medicare and or Medicaid? We talked about that briefly. I think we
So
have to have
tell me the
another live
question.
stream
What was the question?
well, people get Medicare and Medicaid mixed up, the terminology. I think what they're asking, it says, how can a living trust save assets for seniors on Medicare and or Medicaid? The question we usually get is, hey, if I put my assets in a living trust, does that protect them in case I have to go into a nursing home in several years? And the short answer is no. If you put your assets in a revocable living trust where you can do whatever you want to with those assets, no, they're not any more protected than they would be if they were in your own name. We could have a whole nother live
Yeah,
stream on
yeah.
the complex topic of long-term care Medicaid planning. The quickie version, yeah, you've got to get all those assets out of your name. Putting them into a revocable living trust doesn't get the job done. There are other kinds of trusts that are utilized sometimes to start that 5-year look back period.
Right.
But to answer your question, if you're asking about the revocable living trust, which is what we've been talking about, Michael, that's not going to give you any of that kind of Medicaid eligibility planning that you may be asking about. Anything you want to add to that, Eleanor?
Yeah, I think you're right. There are ways to do your estate plan where especially if you know that you may need government assistance for nursing home care, and you don't want to have to spin down all your assets. Now, the government's not going to take your assets, but you're going to have to spend them. And then
Right.
they will, and they don't make you sell your house, but they might be able to get paid back from your estate, if your estate includes your house. So,
Yeah.
so those are but there are attorneys who specialize in that area and can help people set up plans to protect their assets if they believe that they may need to be on government benefits. But anything we do, we have a 5-year look back period generally. So
Right.
we need
Right.
to, you can't wait till it's too late to do that.
Yeah. Can't wait till one foot is in the nursing home to start this Medicaid eligibility planning. So, all right. Any final thoughts you want to add, Eleanor, before we kind of wrap up here?
No, I don't think so, but I really appreciate it. Really appreciate you having me.
Yeah, this has been fantastic, and I put Eleanor's website up on the screen earlier. I'll put the website in the description to the video here if any of you want to contact her and start a conversation. So good having everybody, and